Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. I'm your host for today, Jeny Maier, and the title of today's episode is An Agency in Peril, the Implications of Axon, Louisiana Children's Medical Center, and Other Challenges to the FTC's Power. As those of us in the antitrust and consumer protection community are well familiar, the current administration and leadership at the Federal Trade Commission, helmed by Chair Lina Khan, have been vocal about their desire to expand antitrust and consumer protection enforcement and use all the tools in their enforcement and regulatory toolkit to address harms that they see as taking place across the economy. Contemporaneously with this desire on the part of the FTC for invigorated enforcement activity and the use of certain legal theories and statutory provisions that haven't been used by the agency in recent decades, we're also observing companies taking direct aim at the Commission itself and its ability to take certain kinds of enforcement and regulatory actions. These recent cases present fascinating and challenging questions of constitutional and administrative law. Today, we'll be hearing from an experienced antitrust practitioner and former FTC attorney who will offer us an overview of these challenges that the FTC is facing at the same time that the agency is seeking to flex its enforcement muscles. With me today is my fantastic co-host, Melissa Maxman. Hi, Melissa.
Hey, Jeny.
So, Melissa, would you like to introduce our guest today and kick off our conversation?
I'd be delighted. Our guest today is Matt Tabas, a partner at Arnold in the Washington, D.C. office. Matt's practice focuses on government review of mergers and acquisitions, antitrust litigation, civil government investigations, and antitrust counseling. He regularly represents clients in a wide range of industries, including healthcare, life sciences, medical devices, technology, media and entertainment, telecommunications, semiconductors, consumer products, food, and retail. I hope I didn't leave anything out. Before joining Arnold & Porter, Matt served as counsel to the director of the FTC's Bureau of Competition, where he advised two Bureau of Competition directors on antitrust issues affecting healthcare, life sciences, technology, and chemical industries. While at the FTC, he also worked as an attorney in mergers for, investigating and analyzing transactions in the retail, healthcare, and funeral home industries. Welcome to our Curious Amalgam, Matt.
Thanks. It's great to be here. I'm a longtime listener, so this is fun for me.
Well, we're so excited to have you. And I guess before we get into some of these most recent cases and developments around the FTC's statutory and constitutional authority, I want to go back a little further in time and start with a major development that took place largely at the end of the previous administration. Specifically, the case of AMG Capital Management and the decision from the Supreme Court there, which limited the FTC's ability to seek equitable monetary relief like disgorgement. So I'd refer our listeners to a 2021 episode of our Curious Amalgam on this case if you want to hear more about it. But Matt, can you give us a high-level overview of the key question in that case and how the Supreme Court analyzed it and what that outcome has meant for the FTC?
Sure. So the key question in the AMG case was really whether or not Section 13B of the FTC Act, which gives the FTC the power to go to district court to seek injunctive relief in order to enforce Section 5 of the Act, the substantive provision of the Act that the FTC enforces, whether or not that Section 13B also gives the FTC the power to require defendants to return money that they obtained as a result of their illegal activities. So the power to freeze assets and get monetary relief has been a much bigger deal for the FTC's consumer protection mission But the FTC has also used disgorgement as a tool on the competition side to go after ill-gotten gains from anti-competitive conduct. The case that the Supreme Court looked at specifically involved an enforcement action by the FTC's Consumer Protection Division, challenging an alleged unlawful payday lending scheme that led a district court to order the defendant to pay $1.3 billion for deceiving consumers across the country and illegally charging them undisclosed and inflated fees. So just a little bit of background about the FTC Act and the provisions that were at issue here. So the court was considering Section 13B, which allows the FTC to go directly to federal court to seek injunctive relief. But there's a second provision of the FTC Act that allows the commission to go to court, and that's Section 19, that allows the commission to go to federal court to seek civil penalties and permits district courts to grant mandatory injunctions and such other and further equitable relief as they deem appropriate in the enforcement of such final orders of the commission. So the FTC had used Section 13B to go into court without going through its full administrative process to seek monetary relief. Now, in April of 2021, the Supreme Court issued a unanimous decision that said that Section 13B of the FTC Act does not authorize the Commission to seek or a court to award equitable monetary relief, such as restitution or disgorgement. The Supreme Court came to that conclusion by looking at the text of the statute. The court focused its analysis on the idea of prospective relief rather than retrospective relief, including monetary relief. So the provision of the FTC Act talks about injunctive relief, and that does not mean other equitable relief, according to the court. The fact that there's that separate provision, Section 19, that allows the FTC to get that sort of relief after a final order of the commission confirmed for the court that Congress didn't intend for the commission to be able to get monetary relief in its injunctive actions under 13B. So in terms of what that means going forward and for the FTC's practice, generally today, means that they can go to federal court to stop ongoing conduct, but trying to get relief for conduct that has either ceased or where they're trying to seek restitution or disgorgement, that, according to the AMG decision, mean that they would have to go through a full administrative proceeding, resulting in a final order, and that would ultimately increase the time and cost for the commission to get that monetary relief.
So just to clarify what you just said, Matt, I understand you to be saying that AMG decision differentiates between what monetary relief the FTC can get depending on whether the conduct they're seeking to stop is ongoing currently or all happened in the past. Am I right?
Yeah, so the AMG decision said basically the FTC can't go back in time to try to get disgorgement or restitution for conduct that has ended, essentially. It's looking to stop conduct in its tracks and prevent it from continuing. Here with the rulemaking authority, if the FTC imposes or enacts a rule, and then ultimately a company violates that rule, the FTC can go after that company potentially for a monetary penalty as a violation of the FTC Act. And so it's possible that one of the things that's driving their rulemaking efforts here is desire to really put more teeth into their enforcement actions and have an opportunity to get some sort of monetary penalty out of folks that they believe are engaging in some wrongdoing.
Thanks for that clarification.
And in terms of the likely arguments that we're expecting to see companies make in opposition to the proposed rulemaking, specifically with respect to non-competes, I think you've already seen the U.S. Chamber of Commerce come out and say that they're planning to file suit. in opposition to any final rule that the FTC does. Primarily, the arguments against the FTC's ability to make competition rules is driven by the Supreme Court's recent decision in West Virginia versus EPA, which talks about the major questions doctrine. Essentially, the major questions doctrine is the idea that if Congress wants to give an administrative agency the power to make decisions of vast economic and political significance, it requires clear congressional authorization. The argument being that rules related to competition issues, such as the non-compete rule, potentially have that vast economic and political significance. And so the FTC needs clear congressional authorization, and opponents of the rule are essentially saying that they don't have that clear congressional authorization, particularly given the nature of the antitrust laws, which are somewhat vaguely worded and have resulted in a large body of judge-made case law over the years. It's possible that the courts are not going to allow the FTC to take over that control, but it remains to be seen. There's no final rule from the FTC at this point, so nothing for parties to affirmatively challenge, although obviously we've heard a lot of news and folks making noise about ultimately wanting to challenge those rules if they're enacted.
So, Matt, one of the most significant developments in the last year and the last couple of months relating to the FTC has been the Supreme Court's decision in the Axon case, allowing parties to bring constitutional challenges to the agency's actions directly in federal district court, rather than having to wait for a full administrative proceeding at the agency. So, while the Axon case began during the previous administration, how do you see its impact, the Supreme Court's decision, playing out in the near future with the current FTC?
We're now back at the district court in the Axon case, where the district court will look at the substance of Axon's due process, equal protection clause arguments, and more generally, whether or not the FTC as an administrative agency its structure violates the Constitution. So in the short term, it's not going to have any significant impacts on the process and the developments at the FTC in terms of its enforcement agenda. But over the long term, I imagine whatever the district court decides, either way, either in favor of Axon or in favor of the FTC, is going to get appealed, and this is going to be the start of a longer litigation where the future of the FTC may be somewhat uncertain, or at least Axon's challenges to the FTC's structure and its decisions will be uncertain, and so this is going to be a longer term issue to watch. While the FTC continues to take an aggressive approach on antitrust enforcement. So, but we've got this going on in the background while the FTC, as Jeny, you articulated at the beginning of the episode, they take an aggressive posture towards antitrust conduct, and that goes so far as to extend to areas where some of the commissioners, particularly Chair Lina Khan, have voiced opinions in the past about whether or not certain conduct and certain actors are engaging in unlawful behavior. And the chair has rejected petitions that have sought her recusal. And it's just interesting to see that happen and those petitions be considered in those broader questions as to the FTC structure, and you wonder whether or not those two things will influence each other going forward.
Well, picking up on that thread, given that parties now can bring constitutional challenges to the FTC's authority, have we seen cases in which parties are actually doing that on constitutional grounds? And if so, what are their arguments?
Yeah, so these constitutional arguments have come up in a few different cases recently. So in the Illumina Grail matter, where the commission sitting as an adjudicative body ruled against that merger, The parties have raised a number of constitutional arguments in their appeal to the Fifth Circuit. So in that matter, they've asserted that the FTC's order violates Article 1 of the U.S. Constitution because it's the product of improperly delegated legislative power. They argued that it violates Article 2 because the FTC commissioners exercise vast enforcement, investigative, and prosecutorial authority while insulated from removal. The final order violates the due process clause because the same people who voted out the complaint and or who prosecuted the complaint against the respondents are the ones who adjudicated it. And it also violates the equal protection clause because the respondents would have been subject to different treatment and afforded fewer protections than they would have had in a DOJ challenge. The constitutional arguments are also arising in a few other matters. Microsoft and Activision have raised a number of the same arguments in response to the FTC's Part 3 complaint challenging that transaction. And also an Intercontinental Exchange and Black Knight, another transaction that the FTC has challenged. The parties have raised some constitutional affirmative defenses. In that case, in addition to the ones that I discussed with respect to Illumina Grill, they've also raised the argument that the FTC's Part 3 process violates their Seventh Amendment right to a jury trial and also violates their Fifth Amendment rights as a taking under the Constitution. So there are a lot of constitutional arguments getting thrown around. It remains to be seen whether or not the courts will actually take these up. One of the issues with merger challenges, particularly when the FTC is seeking to challenge a merger that hasn't closed yet, is there tends to be a time limit to how long the parties will ultimately litigate the transaction and how much they will fight it out, how long the transaction will ultimately hold together before it closes. And so some of these constitutional arguments take such a long time to work their way through the court. If the parties aren't successful initially, and are allowed to close their transaction, it's unclear whether or not they'll ultimately get litigated all the way through to a decision. In the meantime, however, these are arguments that the FTC now has to take seriously in light of the Axon case and certainly a federal judiciary that I think currently, particularly at the Supreme Court, has demonstrated a willingness to entertain these sorts of challenges to the administrative state, and certainly in Justice Thomas's concurrence to the Axon decision suggests that some of the actions by administrative agencies like the FTC may go beyond the bounds of what the Constitution allows.
It's a really interesting point you made there at the end about timing and sort of the duration of these litigations and whether they're capable of being litigated in the same time period that a merger is going to be held together. But really looking forward to seeing what happens here. But now let's maybe transition a little bit from talking about kind of these constitutional arguments about the FTC's structure and talk about a kind of a wholly different but kind of equally threatening attack on the agency's merger enforcement powers. And that's the case of Louisiana Children's Medical Center versus the FTC. Matt, can you tell us a little bit about what that case is all about and why you think it's so significant?
Sure. And I think it does tie back into that point about these constitutional challenges that get litigated after an FTC challenge, in the sense that in this case, the parties have affirmatively gone to federal court to seek a declaratory action against the FTC that essentially Louisiana's Certificate of Public Advantage program immunizes their transaction. This is Louisiana Children's Medical Center and HCA entering into a potential transaction that it immunizes their conduct under the state action doctrine. So the state action doctrine was adopted by the Supreme Court in Parker versus Brown. It essentially immunizes actions by the state from the antitrust laws. So unless specifically intended by Congress, federal law should not limit a state actor's authority. And the Supreme Court held that antitrust laws did not fall into the category, so state actors would be exempt from antitrust enforcement. That doctrine was extended to private actors in certain circumstances by California Retail Liquor Dealers Association versus MidCal. And there are essentially two prongs to the analysis to determine whether or not a private actor can benefit from state action immunity. The first is whether or not the challenge restraint is one that is clearly articulated and affirmatively expressed as state policy. And then the second is that the policy must be actively supervised, the state itself. So the parties in the Louisiana children's case essentially said that Louisiana Certificate of Public Advantage program or COPA program does just that. That instead of being subject to the antitrust laws, they're immune as a result of a COPA approval. And so not only are they immune from any sort of enforcement down the road, but also they're essentially exempt from the filing obligations under the HSR Act. So instead of filing and waiting and dealing with the time and expense in responding to an FTC investigation, the parties there filed the declaratory action to shortcut the whole process and try to seek the relief that under the Constitution they're protected from that FTC scrutiny. And the goal there presumably was to deny the FTC the opportunity to do its investigation and potentially develop a case in which it would ultimately seek to challenge the transaction. The FTC, for its part, has responded that the HSR Act is that there's nothing in the state action doctrine that immunizes or exempts, the parties here from their filing obligations under the HSR Act, and that the point of the notification is to give the FTC the opportunity to determine for themselves which mergers warrant further scrutiny and which ones they ultimately want to challenge. The FTC, in its brief, said letting merging parties unilaterally refuse to file under the HSR Act because they claim that they may have a defense to a possible future antitrust challenge would frustrate the purpose of the HSR Act. In response, the parties are basically saying that Louisiana's COPA law is intended to do just that, and so they should benefit from the state action immunity and not even be required to file. So it's in the same vein that some of those other cases challenge the underpinnings of the FTC's enforcement ability and its administrative process. This case, could challenge the FTC and DOJ's ability to enforce the HSR Act vis-a-vis hospitals and healthcare providers that may be able to take advantage of the COPA proceedings in various states.
So where do you see all this heading? Do we have another big case in the Supreme Court in the future coming up, or are there cases that antitrust lawyers should be watching?
So of the cases I've mentioned, it's hard to say which one is going to end up at the Supreme Court. There are a number of different transactions or I guess challenges that are already at the appellate court, particularly Illumina Grail, which is an appeal of an FTC decision. That's already at the Fifth Circuit. So it's possible that if the decision comes out a certain way, that either the parties or even the FTC will petition the Supreme Court for cert. This is certainly an area that I think the Supreme Court has taken an interest in, particularly as it relates to the powers of administrative agencies. And in one case along those lines, outside of the antitrust context, that I think does bear some watching is Loper Bright Enterprises versus Raimondo, which is a case that the Supreme Court recently took up and it essentially asks whether or not the court should overrule the Chevron versus Natural Resources Defense Council standard, or whether or not the court should at least clarify that statutory silence concerning controversial powers expressly but narrowly granted elsewhere in a statute does not constitute an ambiguity requiring deference to the agency. So that Chevron standard essentially holds that a court may not substitute its own construction of a statutory provision for a reasonable interpretation made by the agency where Congress has not spoken directly to the issue. So from an FTC practice perspective, while the FTC has not historically relied on Chevron deference for its administrative decisions in connection with its enforcement actions, it's relied traditionally on the more stringent review standard, the substantial evidence standard. And that gives circuit courts a greater ability to scrutinize its decisions, which in plenty of instances they have. Where this question about whether or not Chevron remains good law is, where that is going to come into play potentially, goes back to the rulemaking that the FTC is considering. Given that they're going through a whole notice and comment period, the Chevron deference could have been, if it remains, could be a way in which the FTC defends its decision in court, and essentially, from a procedural perspective, say that the court needs to defer to its expertise. So, if Chevron's overruled, they may lose that opportunity ultimately down the road if their rulemaking does get challenged in court.
So I know you don't have a crystal ball, but given the current makeup of the court and the various seismic changes in approach that's taken on a variety of issues, how would you predict? What do you think is going to happen? What do you think is going to happen to the Chevron doctrine, which we all dutifully learned in ad law school?
Exactly, it's taking all of us back to law school. But I think it's hard to say exactly how the court will rule on any one issue, but certainly this seems, I think most commentators are expecting they wouldn't have taken this case if they weren't thinking seriously about overturning it. So we'll see, though, ultimately whether or not they get rid of it completely or whether or not they limit it in some way or take some other result. We will see. It I think will be interesting to watch.
I couldn't agree more. So we're now going to turn to the last segment, traditionally, of our Curious Amalgam, which is when the listeners, get to hear a little bit more about you personally. And can you tell us, the first question is, can you tell us something about us interesting that we wouldn't know if we only knew you professionally?
So I don't know what it says, but this one was hard for me. But I'd have to say that it might be my love of barbecue and the fact that I've traveled around the country to try to find the best barbecue restaurants in lots of different regions, and getting an opportunity to taste the barbecue of Texas, of Kansas City, of St. Louis, of North Carolina has been one of the real fun experiences of my life, I think, thus far.
And who's the winner?
Well, my wife is from North Carolina, so I don't think I would be allowed back in the house if I did not say North Carolina. But specifically within North Carolina, there's a region called it's the Piedmont region of North Carolina. They have a specific type of barbecue that's a little bit different than your traditional Eastern Carolina barbecue, and I'll have to give them the winner. Not the least because my wife is from that area.
All right, Jeny, you want to turn to the Curious Hat?
All right, Matt. Well, we will move to the section of our program called The Curious Hat.
And now it's time for The Curious Hat!
If you have heard this program before, we will have our imaginary hat here with a number of 1 to 10. We will ask you to choose a number between 1 and 10.
Let's go with 7.
Okay, reaching into my hat. And all right, on the subject of food, per your last answer. Is there any popular food item that you dislike intensely?
Ooh, that's a hard one. I don't think so. I know that some listening may find that shocking, but there's nothing that jumps out. When I was younger, I was quite the picky eater, but over time, that has changed, and I'm pretty adventurous when it comes to food now.
An omnivore.
Exactly.
Well, Matt, thank you so much for joining us today, and we look forward to everyone joining us again next week on Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.